Good afternoon. Today we're going to talk about handout 10 on Blackboard. When you print it up, if you open it and look at it, it's called handout 10A, but it's the same thing. It's a purchase and sales agreement, a draft of one, a sample that I've done up based on the format that we use in our office when folks do not have a real estate agent. What normally happens in situations, particularly in consumer situations in Rhode Island, is that the real estate agents have a standard form that the Association of Realtors has promulgated over the years and changes from time to time. And 99% of residential transactions use that format. And as a matter of fact, very often, real estate agents are somewhat leery and weary of attorneys. They don't like us getting involved in the process. They feel we complicate it, delay it. So very often I do not even hear from my clients until after a purchase and sales agreement has been signed, and they come to me saying as sellers they now need to get ready to go to a closing, or as buyers they need a title examination done. So very often attorneys in Rhode Island are not involved in this process. Now that's very different in Massachusetts, and particularly the closer to Boston you get, as the prices go up higher and higher, and even a residential transaction can easily involve $1 million. The realtors at this point in time, most of them encourage their clients to go through attorneys, and even though they do have standard real estate forms that vary with the local county real estate boards in Massachusetts, very often we lawyers get in and we end up almost tailor writing something for each transaction. At any rate, this is a Rhode Island agreement that, again, we use in my office. It's very similar to the agreement that the Association of Realtors use, but it is not theirs. It is something that we have drafted and used and amended as things change over the years. If you look at the first page, several things. In order to meet the statute of frauds, right in the first paragraph, we have the names of the parties, and we have statement as to who they are. So John and Mary Smith are the sellers, and Harry Jones and Judy Jones are the buyers. Next, again, to satisfy the statute of frauds, we have a description of the property. Now, in Rhode Island, we normally describe the property just by the mailing address. So here you see it's 32 Main Street in the town of Ashaway, County of Washington, State of Rhode Island. Very often, for reference, we also put in something called the assessor's plat and lot. A tax assessor in each town, as we talked about a few weeks ago, it has a job of looking at every piece of real estate, assigning a value to it, so that when it comes time to assess the real estate taxes that year, the tax collector knows how much tax they are entitled to from that piece of property. And in order to keep sense and order in this, in Rhode Island and in many of the nearby Massachusetts towns, a system has developed where they divided the town up into maps, which in Rhode Island we call plats, and then they took each separate parcel on that map and assigned it a parcel ID number. And again, those are very handy things, and very often they help whoever's doing the title exam get into doing the title work, because very often the assessors keep good records as to what deeds are in the chain of title, who owned the property over various periods of time, which is the basis of any title exam. So for our parcel here, we see it's on plat or map 32, lot 55. It is further described in Exhibit A attached here too. Now that is something we do that the real estate agents normally do not. There are legal descriptions for every piece of property, and when we get into looking at a deed in a few minutes, I'll explain them in more detail. But the legal descriptions are what actually tells us exactly what the parcel of property is. That is what gets recorded in the land evidence records to show who has ownership of what. They tend to be, in many situations, rather long and cumbersome things, so people do not like to include them when they do not have to. For a deed and mortgage to be valid, they have to have the legal description included in the document that gets into the records. But for purchase and sales agreement, it is not a requirement. Now, as attorneys, out of abundance of caution, we like to put the Exhibit A there, because then it tells us exactly what is being bought and sold, because street addresses can be somewhat confusing and they don't necessarily apply to all of the parcel, or sometimes they, if a parcel is being subdivided, they only apply to a portion of the parcel. And the same thing with assessor's plat and lot numbers. They are not a legal guarantee of what the actual property is, so that we have to be somewhat careful with them. At any rate, two things for the statute of frauds already: identifying the parties, identifying the property. The next thing, date of the agreement, just tells us what date this is signed, because certain things such as filing an application to get a mortgage or doing your inspections, you're only allowed so many days from the date of signing. So it is important to define what the date of signing is, particularly because in many situations, in most situations, the two sides do not come together to sign this. It's carried back and forth, and today it's emailed back and forth between the real estate agents or the attorneys, and therefore, very often, the signatures do not get put on the document on the same date. So because you're going to end up with a document that has multiple dates for signatures, we need some definition as to, all right, what is the date of the agreement? And it is the date when the last person who needs to sign signs under the provisions of our form. Third thing that we need to satisfy the statute of frauds is the purchase price. And here you see we have it broken down. $460,000 is the total purchase price. $1,000 had been paid when the parties, particularly the buyers, had handed in an offer form to show their good faith. And now the sellers are asking for an additional $12,000 to be held in escrow while the purchase and sales agreement and the transaction is pending, meaning that at closing, the buyers are going to have to come up with $447,000. And again, bringing the total back up to $460,000 if you add all those items together. Because there are no particular realtors involved in here, because we wrote the contract, we have agreed to hold the deposit in our client trust account. By law in both Rhode Island and Massachusetts, all deposits on the purchase and sale of real estate have to be held in what's called a trust account or a client escrow account. These accounts are not the property of the real estate companies, nor are they the property of the attorneys. As a matter of fact, you have to use great detail in keeping these accounts, making sure that every dollar that goes into the account is accounted for in terms of which client owns that money. And were the real estate office or the attorney to get into financial trouble or to go bankrupt, these funds are not part of what would be in the bankruptcy. These funds belong to the named parties who have put money into the account. The time of performance. We see we have set a date for July 16th at a mutually agreeable location. In Massachusetts, very often they will do closings at the Registry of Deeds, which is kind of an interesting concept, but it was done in the old days because right at that point in time, the sellers would sign a deed, hand it to the buyer's attorney, he would go up to the counter, file the deed, and once it was filed, the check would be handed to the sellers. That has become a very cumbersome process in the present day. If parties, the buyers, are taking out a mortgage, very often the closing package that they have from the bank runs over 100 pages. And very often things need to be changed even during the course of the closing. If you're sitting at a Registry of Deeds office without your support staff, without your computer present, that can often be difficult to do. So more and more, even in Massachusetts, it's become the custom to do the closings at one of the real estate agent's offices or one of the attorney's offices. In Massachusetts, the local cities and towns handle the recording. They have never provided places for doing closings. As a matter of fact, if a group of people walked in and tried to commandeer the tables to use them for 2 hours for a closing, they'd probably be summarily put out. So in Rhode Island, the transactions have generally taken place at either the lender's office, whoever is loaning money to the buyer, or at the attorney's office, and in more recent years at the real estate agent's offices also. The time of performance, we see here, we have put in time is of the essence. Again, we talked about this previously, I believe, but time of the essence is the magic words which say that I want this contract, we demand this contract be performed exactly at the date and time we have stated here that it is to be performed. If you do not put that language in, then any date becomes a reasonable date. When you're dealing with a nearly $500,000 transaction, what is reasonable? I'm not sure that a month or a 2-month delay would be unreasonable in the eyes of a court. So more and more often we are seeing this put in. In Massachusetts, it is always placed in the agreements. Rhode Island, much less so, and lawyers and realtors tend to fight against it in Rhode Island on the theory that they don't want the whole deal to blow up if we've missed everything by one day. The next clause is a very important clause, and again, in residential transactions, 99% of them will have this clause. It's a mortgage contingency clause. A contingency is a condition. And here we are conditioning the contract on the buyer's ability to borrow the whole purchase price, $460,000, at prevailing interest rates and closing costs. And it says the buyer shall make diligent efforts to apply for said mortgage within 5 days. Now here again, this is the first one of those items where it's important to know what was the date that the contract was actually signed and goes into effect, because the buyer only has 5 days from that date to apply for a mortgage if they want to preserve this clause. Basically what this clause says is if the buyer is unable to obtain a mortgage commitment by May 4th, 2020, the buyer can tell the seller that. The seller shall have the right to cancel the agreement and return the deposit if they don't want to wait, or the parties can agree to extend the contingency date at that point by an amendment to this contract, or the buyer can just say, we're done, we want our deposit back, we cannot get a mortgage. So the purpose of the mortgage contingency is to allow the buyer time to make sure that they can qualify for a loan. Now, they should have been doing their homework on this previously, and a good buyer's broker, before they actually take anybody out to start showing them houses, will have sat down and worked with the people to make sure that they qualify to buy the house in the value range that they're looking for, that they either have cash or they have financing. Okay, still on page 2 near the top, talking about fixtures. By common law, anything that is permanently attached to the property, even though it began as tangible personal property, is part of the real estate, and unless it's specifically excluded in the purchase and sales agreement, would automatically go with the property and become the property of the buyer. You'll see, however, they've listed a long list of things here. We've listed a long list of things stating that these are to remain on the property and to be left. So we're kind of repeating the law unnecessarily here. I think one of the reasons that we do that is most people don't understand, even if you explain to them, oh, well, anything that's attached has to stay. So if it becomes an issue because the sellers have taken down Aunt Mary's chandelier from the dining room after the buyers had looked at the property, and that was one of the reasons they were buying the property, we can point to this clause, point both sides of this clause and say, look, you agreed that you were leaving all these things, buyers, that they were staying here. Title. The premises are to be conveyed by a warranty deed. Now, in Rhode Island, we use warranty deeds almost exclusively, and in Massachusetts, we would tend to use quitclaim deeds rather than warranty deeds. When we get to the section going over a deed as a specific document, I will explain that in a little bit more detail, but the idea here is that the buyer gets the right to take the property with good title, get a warranty deed from the seller, and that the title will be marketable, which means it's accepted in the legal world, in the real estate world, as a clear title, as a fee simple, and that it's free from encumbrances and accept easements and restrictions of record and municipal regulations. One of the things, I think I talked about this in the last lecture, that really concerns me, again, very often I don't get to see this agreement until it's already been signed. The realtors have set up the parties and had it signed, and then they come to me. And one of the things that happens in both Rhode Island and Massachusetts, when you sign a purchase and sales agreement, you are agreeing to accept whatever easements, restrictions, covenants are on that property, bylaws of the condominium, unless you specifically exclude something or give yourself the right to have so many days to review those items to see if they meet your needs. So just beware as you go about in the future buying real estate that this is something you need to do. And before you sign to buy a piece of property, you need to either have checked the restrictions and the covenants or put in your contract you have so many days to do that and have a clause, a condition in there that if you don't like the restrictions or the covenants or the condo rules and regulations and bylaws, that you have the absolute right to get out of the agreement. Possession. It is presumed, and it is stated here in the contract, that as of the date of closing, the sellers will be out of the premises. Their furniture will be gone, their pets will be gone, their relatives will be gone, that their tenants will be gone, and that the property will be left in what we call broom swept condition, which means they don't have to make repairs, they don't have to touch up the paint. However, they're not allowed to leave trash or junk or debris or items that they didn't really want to take, that unless agreed to otherwise, the seller has to empty the property entirely and the buyer gets to move into and take possession of a property that is empty with no personal property items and certainly no leftover people in it. If you want to change that, you have to have in the agreement that that is not going to be so. Very often, part of the deal is people like buyers like a certain piece of furniture or a certain living room or bedroom or dining room set, and it is agreed between the parties that will remain. That has to be specifically written. When we're dealing with multifamily properties, very often a number of the tenants will be staying, but there again, that has to be stated. As a matter of fact, there's a separate version of this document that deals with multifamily properties, and in it actually has provisions that talk about what tenants, what unit numbers are staying, and what ones are leaving, and what ones have to be vacated by the date of the closing. The next one, most lay people, non-attorneys, non-real estate people don't understand this, but it's very important. It says use of purchase money can be used to clear title. If the seller has a $400,000 mortgage on the property, that has to be cleared to give good title. That has to be paid off so that the buyers can buy the property not subject to that mortgage. Most often, the sellers do not have money in their pocket to pay that off ahead of time. So what happens is the closing attorney for the buyer, and usually it's the same attorney for the buyer's bank in Rhode Island, they will act as escrow agent. They will take all the funds, and the seller will not receive $460,000 at the closing. Instead, the $400,000 they owe on their mortgage will be taken out, sent to their bank to pay that off, and they will receive the $60,000 balance. So that's what that clause says in rather simple language, that it gives the closing attorney the power to make adjustments among the funds. Likewise, most properties today, particularly if they're in urban areas or fairly built-up suburban areas, there are a number of charges besides the real estate. So there's water service, sewer service, there may be gas service, there may be oil in the tank if the heating system runs on oil. All these things will be apportioned as of the day of the closing. We'll take final readings and attempt to get a final number that the sellers have to pay. Those funds will be taken out of the closing. And on the buyer's side, the buyer will start off running with new accounts as of the day of the closing with zero balances. Now, in Massachusetts, particularly in the towns in Bristol County, it's a custom that has arisen over the last 100 years, which is somewhat strange to my reckoning, but it's the way things are done. So if you're buying or selling a property in Attleboro, North Attleboro, Seekonk, Swansea, you need to be aware of the fact that they do demand that these items be paid in advance. So several days before the closing, the sellers have to go to the folks who handle these things, which for water and sewer are usually the local municipality or some intercity, intertown board, and make sure that they pay up the bill to date and that they bring receipts to the closing showing that these items have been paid. In Rhode Island, We tend not to do that. We tend to get readings. We tend to come up with a number that it's worth and deal with this right at the closing. Real estate taxes and fire district taxes, which a number of the towns in Rhode Island have separate fire districts that can impose real estate taxes the same way that the towns do. We always look at the present year real estate taxes. Now, all prior year taxes have to be paid. So if any of those are outstanding, then they are, again, taken out of the seller's proceeds and they are paid in full with whatever interest and penalties might be due on them. But for the present year taxes, the tax collectors in the cities and towns in Rhode Island refuse to deal with this process. They don't want the liability. They don't want to spend the time and effort. They don't want the work. So when it comes time to transfer a property, it is up to the parties to decide what's going to happen with the taxes. In Rhode Island, what we normally do is we take the tax bill for the entire year. We divide it by 365. We determine what day of the year we were on and then multiply it by that number we got, that 1 day amount for the tax bill. And the seller is responsible at the closing for either having paid for it to the town or giving a credit to the buyer for everything up to that day. Then the buyer becomes solely responsible for paying the taxes for the rest of the year after that. Right? Assessments. Very often, if a town is installing sewers, sidewalks, water pipes, repairing the streets, they will assess something called a betterment or an assessment. It is a form of a tax, but it's in addition to your regular real estate taxes. And normally the way these work is that, I know in Lincoln, when we were moving into our property 30 years ago, Lincoln had just built its sewer system, and they assessed every piece of residential property in town with a sewer $2,000 betterment. Those could have been paid over 10 years as part of your tax bill. However, very often when it comes time for a sale, two things can happen. The parties can agree that the seller will only pay what's due up to the date of the closing and the buyer will assume the rest. Or what's become more common in recent years is that the seller has to pay off the whole thing at closing and then the buyer buys the property free and clear of the assessment. Depending how the contract is written will determine what happens. I believe here we have them split between buyer and seller. Insurance. Homeowners insurance is a very important reality because it provides for a situation if the house is damaged by fire or storm or other casualty, that the property can be rebuilt and restored. An interesting thing happened at common law. At common law, the minute the buyer signed the P&S agreement, they became the equitable owner of the property. And at common law, that meant they assumed the burden of risk. Now, what the burden of risk is if something happens to the property, who ends up losing? So at common law, if you sign the P&S agreement to buy a house and the house burned down the next day, you still have to go through with the transaction and buy the land. 300 years ago, that made sense because the land was far more valuable in those days than any of the buildings that were placed upon it. But today, that's kind of a ludicrous reality in that the buildings are usually far more valuable than the land itself. So today, the courts have never changed the law. The legislature has never deemed to change the law. So instead, every P&S agreement in both Rhode Island and Massachusetts has a clause similar to this, which says that the seller must keep the property insured up until the day of closing, and if there is a casualty, the buyer has several options. One is they can say to the seller, restore the property to where it was before the accident occurred, using the insurance and using whatever other money you have. If there is no insurance or not enough money to do that, the buyer has the ability to walk away. Or if it's some kind of minor damage and it still doesn't get repaired or paid for, but the buyer wants to take the property subject to it, the buyer can do that. The buyer only becomes responsible for insurance from the day of the closing forward. The clause about notices just says how we're going to send notices to each other should we need to provide information, and more those are coming to be handled electronically with electronic signatures. In the last year or so, most of the purchase and sales agreements I've gotten have electronic signatures on them. So this is moving fast and furiously into the day and age of the internet and into electronic documents. The Rhode Island real estate sales disclosure form. In every residential transaction in Rhode Island, you must hand the seller must hand the buyer a document that has a list of a whole bunch of different things talking about condition of the property that the seller is supposed to have filled out. I will attach a blank one of these to Blackboard so you guys will get to see it. Now, as we get to the middle of this page, we get to the thing called buyer's information. The legislature has been sticking their hands in this business for the last 40 years, more and more frequently, particularly in light of consumer type things where they're afraid that people were not always being told the entire truth about the property, or that they were being swindled in some way or being led into transactions that they normally would not want to have gotten into. So a number of things now have to appear in the purchase and sales agreement, whether the parties want it in there or not. And you would find these same clauses in the Realtors Association standard contract, standard agreement, and of course, because they're required by law, we as attorneys put them in our agreement. A number of those things. Local ordinances. This is letting you know that there are local zoning rules and local realities that may affect what you want to do with the property. Many places where there is single family residential zoning, if you were to buy that building to try and open a boarding house or a fraternity house, you would not be allowed to, even though you were using it as a residential property. So it's basically a warning that if you're going to do anything a little bit unusual with the property, you need to check the local zoning and other ordinances to make sure you're in compliance. Wetlands. In Rhode Island, the Department of Environmental Management has control of anything deemed to be a wetland. A wetland can be any property within 100 feet of a stream, a pond, a river, a lake, or any land that is partially moist or damp or boggy for a part of the year, or it can be a piece of land that seems to be totally dry, but it has certain flora and fauna upon it. If a property is a wetland, there are severe restrictions as to what you can do on it, and there are restrictions as to what you can do within so many feet of the edge of the term wetlands. There is a rule that says sellers are required to declare wetlands if they're on their property. In many situations, particularly in residential situations, it's never been tested, it's never been properly checked out. So we put in a clause that basically exonerates the sellers and says, this is a wetland. We declare everything to be a wetland, and again, if you're a buyer, you need to check this out. Normally, if there's already a house in existence, if there has been a building certificate of occupancy issued by the town for that house, saying that it meets the zoning, ordinances, whatever, wetlands would not be an issue unless you went to expand the building or the garage or to build a new septic system. Then wetlands could become an issue. But if you're buying the property to keep it exactly the way it is and it's already completely built and finished and a certificate of occupancy has been issued, then you're usually safe and wetlands are not an issue. Radon gas is a radioactive gas that is emitted by different types of rock, most formally granite, which sits under all of New England. We sit on a massive piece of granite, and throughout time, this granite breaks down, releases radioactive gas, and eventually that gas works its way through the ground, through the subsoil, up into the atmosphere. This can accumulate in basements and enclosed areas that are in contact with the ground. Now, prior to the 1970s, when everybody became energy conscious, radon was never an issue because most of the houses were so leaky that every 20 or 30 minutes you had a total exchange of air between the inside and the outside of the house. But after the oil crises of the 1970s, when people became very energy conscious, they began tightening up their houses and stopping that exchange of air between the inside and the outside. And then lo and behold, people started discovering they had incredibly high levels of this radioactive gas within inside their house. So beginning in the 1980s, the legislature passed a number of laws stating that people have the right to inspect for radon And if radon is found, there's a number of mitigation systems that can be used to get rid of the radon. The most common system that I've seen is that they put in some piping, some PVC piping from the basement area up into the outside, and they attach a blower similar to the blower that might be on the fan in your bathroom, and they put it on a timer so that so many times an hour there's air being flushed out of the basement, air being taken in from the outside, and usually in 99% of the cases that will keep the radon level extremely low and below what they consider to be safe levels. Lead contamination. Right? Lead was a component in most types of paint prior to 1978. Lead is the substance that causes paint to stick to other surfaces. And it was also, if you wanted a high gloss shiny paint, it was the thing that gave it that high gloss and that shine. So it was particularly used on moldings, on window sashes, and on pieces of wood, on doors, door frames, on things that would come in contact with everyday use. And over time, if the paint chipped, and particularly if the paint chips were crushed into powder, lead dust would get into the building. And this was found to be extremely detrimental to young children. And so beginning in the 1970s, there was a campaign to eradicate lead, to make people aware of lead poisoning, and to provide for residential situations to allow parents to determine if there is lead paint or not and take the proper precautions if they have young children. In Rhode Island, the vast amount of the housing stock is older than 1978, so we have to presume there is lead paint there. The only thing you're required to report is if a child was actually poisoned with lead and that any inspections were done, or if you had inspections done. Many people have lead inspections done today if they have small children and they're buying an older house. When they go to sell, they need to report what that inspection found. Rhode Island is not particularly severe on what happens with lead. If you have a child under 6 who's going to live in the property, you have to do lead remediation, which means you have to make it lead safe. You have to cover whatever surfaces have lead paint on them so that they're not chipping and they're not creating dust. And covering them can be something as simple as painting anything up to about 4 feet or 4.5 feet in height where a young child could reach with special paints that exist to prevent lead paint from chipping, to prevent the underlying paint from becoming loose. Certainly putting up new sheetrock, putting up paneling, other types of things, barriers that would keep the lead from coming into contact with the atmosphere and being ingested by small children would suffice. For many years, Massachusetts had a very severe lead remediation rule where if you found lead in paint in a house, you had to go through and remove all the lead paint. Well, on most houses, particularly in the older houses where wood molding was everywhere, this became a ridiculously expensive and difficult process. And after a number of years, they began to find out that even after they spent hundreds of thousands of dollars de-leading a 3 or 4 family house in Dorchester, the lead, as part of the de-leading process, lead dust would have been forced into the walls, into cracks and crannies that they couldn't vacuum out. It would eventually start working its way out. So there were several cases where houses where hundreds of thousands of dollars of lead remediation were done 5 or 10 years later ended up having lead issues again from the residual lead. So now Massachusetts has also moved to a lead safe type program where you get to cover the lead. You do not have to remove it completely. All right, Clause E is just a statement that again, you are responsible for determining if there are any municipal regulations, which would normally be zoning codes, subdivision codes, building codes, that would affect what you want to do with the property. In commercial situations, these become extremely important, and we usually put languages in that the buyer will obtain a zoning certificate stating that their intended purpose will be allowed by the city or town. As I said, the legislature went crazy with these things over the last few years. So as we go on to the next page, there are additional things that the legislature says we have to include in every contract for a residential property. It is now the law in Rhode Island that every time a residential property changes hands, there must be smoke and carbon monoxide detectors located in that property according to whatever the code says. Now, when you get up into 3 and 4 family houses, sometimes the code means that these have to be hardwired systems. And a hardwired system for this type of detectors usually means metal piping going through the walls to contain the wires so that they can't be easily burned or cut off. And it means a panel box very similar to what you might see in commercial establishments when you walk in, setting up zones and being able to tell which smoke detector is going off, where the fire or the smoke is within the building. They can run into tens of thousands of dollars. For single families and 2-family residences, battery detectors are still allowed, but they must be present, and at least within 60 days before the closing, you must have somebody come in from the local fire department, inspect the detectors to determine that they're working and that they're placed where they are supposed to be placed by code, and then they will issue you a certificate saying that there are smoke detectors that meet the state requirements. Most lenders at this point will not allow a closing to go through unless a certificate has been provided before the closing is set up. Even if you have a hardwired system, you still have to have the inspection done so that they can inspect to make sure the hardwired system is working the way it's supposed to work. Rhode Island imposed, about 25 years ago, a non-resident withholding tax. So anytime some individual, corporation, or trust that is not a Rhode Island trust sells a piece of property in Rhode Island, there must be a withholding of taxes to make sure that these people pay their capital gains taxes due to the state and do not abscond outside the territory of the Division of Taxation to places where they can't get their money. For individuals, it is a 6% withholding. For corporations, it is a 9%. There is a form, a document, or a series of documents that can be filed before the closing so that if people do not owe capital gains, you can have the state review the transaction and provide a document, a stamped document showing that they've reviewed it so that the closing attorney does not have to withhold anything. If you are a non-resident and you show up at a closing without that form, the attorney is required to withhold 6 or 9% of the total proceeds, send them off to the Division of Taxation, and then it's up to the seller and their accountant to fight with the Division of Taxation to get that money back. FIRPTA, the Foreign Investment in Real Property Tax. The federal government also has a withholding tax on foreigners who sell property in the United States, again, to make sure that they pay their capital gains taxes before they disappear out of the country. So at every closing, the sellers are going to be asked to sign a form showing that they are either a citizen or a legal resident of the United States, and if they are not, then it is a 15% withholding tax that will be withheld and sent to the federal government. And again, then the seller, after the closing with their accountant, will fight with the government to determine if they should get any money back or not. Zoning, again, making it very clear, seller makes no warranties as to the status of zoning. It's up to the buyer for determining this. If the seller is unable to give good title or to make conveyance because something has happened to the property like it's damaged, all right, all payments made by the buyer under this agreement will be refunded and all obligations will cease. So in effect, the contract is void at that point. The buyer gets their money back. However, the buyer may waive any defects or any title problems and take whatever is there. However, if they do that, they have no right to demand a reduction in price from the seller. So if something comes up like that, where the buyer's unable to give clear title or some other issue has arisen with the property that would stop the conveyance, 99.9% of the time the buyers take their money and go on to buy another property. If the buyer defaults, the seller shall have the right to retain the deposit as liquidated damages. We may have talked about liquidated damages a little bit in the last chapter, in the last talk that I gave. However, I'll go over it again now just quickly. It is permissible for parties to put in an agreement, in a contract, what the minimal damages will be if there is a breach by one party, both parties, the other party. or the. So what happens is here, if a seller has their property tied up for 6 or 8 weeks, waiting for the buyer to buy, and the buyer doesn't buy, the seller has incurred certain losses, certainly the taxes, interest on their mortgage, other expenses that accrued. But it's very difficult. The seller has lost time. They may have lost their ability to buy another house. They may have lost their ability to move when they wanted to move. There are a lot of intangible things that are very difficult to put a price on. And this is the whole point of liquidated damages. In situations where it's difficult to assess contract damages, you set an amount ahead of time that says, if you breach, Mr. Buyer, this will be the minimum of your damages. And in real estate contracts in both Rhode Island and Massachusetts, the amount that you put down as a deposit is the liquidated damage amount. Now, a couple of things about this. If you're a seller, you want to try and get the deposit as high as possible, because that will put it in the buyer's mind that will do anything not to breach. If you're a buyer, you want to get that deposit as low as possible, because if for some reason you need to walk away and there's no contingency for why you're walking away, you want to be able to get out of the agreement and get your money back. Or if you're going to lose your money, you want to lose a minimum amount. So negotiating the amount of the purchase and the amount of the deposit under the purchase and sales agreement is an art form, and depending who you're representing in the transaction, there are absolutely 2 different theories of how you go about that. All right. If the seller defaults, one of the things that the buyer can do is demand specific performance. Specific performance is the idea they can force the seller to sell the property, to sign it over, as long as they give over the purchase price. The courts in real estate transactions are absolutely rabid about enforcing this. So if you sign a P&S agreement to sell your property and then you get seller's remorse, it is too late. If the buyer insists, they can force you to sell that property to them, even to the point of having you brought into court and ordered to sign the deed. And if you refuse to sign, you're held in contempt, and the judge will just issue a court decree giving the property to the buyer, as long as the buyer comes up with the purchase price. Construction of agreement is just contract language saying that these contracts apply not just to the parties who sign them, but to their assigns, administrators, executors, to anybody else. That if more than one person signed, their liability is joint and several, meaning they're both and all liable for everything, and that they will probably have multiple copies of this document, any of which can act as the original. We must disclose the selling price. Under Rhode Island law, the selling price must now be in the deed and declared to the public, and it also has to be disclosed to the Internal Revenue. Whoever conducts a real estate closing is required to send what's called a 1099 form to the United States government, Department of Internal Revenue, to let them know that a transaction has happened and to put them on alert to look for capital gains. All right, I think I'm going to stop here, as we got to almost 45 minutes, and I'll pick up with brokers on the next to the last page of the purchase and sales agreement, and we'll go over some documents in the next transaction.